Let me tell you about Carmen Reyes, 36 years old, licensed clinical social worker and senior case manager at Brightwell Family Services, a nonprofit family services organization in Colorado that provided foster care coordination, adoption support, and family preservation services to the state child welfare system. Carmen had been at Brightwell for 8 years. She had built the organization's adoption support program from a loosely organized collection of referrals into a structured, documented, replicable system that had helped 214 families complete adoptions over 6 years. She had also, for the previous 3 years, been working through the process of adopting a child herself. A 7-year-old boy named Marcus who had been in foster care since age 4 and who had been placed with Carmen as a foster child 18 months earlier. Carmen knew the adoption process intimately. She had walked hundreds of families through it. She understood every form, every court date, every home study requirement, every agency approval step. She also knew that the finalization hearing, the legal moment when an adoption becomes permanent and a child becomes yours, was not something that could be rescheduled around a supervisor's preferences. The hearing was set. The date was fixed. The judge had a calendar. The child welfare attorneys had a calendar. The court had a calendar. Carmen requested leave for the hearing date and the 2 surrounding days, which her adoption attorney had advised her to take for preparation and for giving Marcus time to process the transition with her present at home. 3 days total. Her supervisor, Regional Director Sandra Holt, denied the request. The reason Sandra gave was operational. Carmen was the lead case manager on 3 active foster care transitions that week. Her presence was required. Carmen asked whether coverage could be arranged. Sandra said coverage was not available. Carmen asked whether the hearing date could be cited as a qualifying reason for Family and Medical Leave Act protection. Sandra told her that FMLA did not apply to adoption finalization, and that Carmen should arrange for her personal matters to accommodate her professional schedule. Sandra was wrong. The Family and Medical Leave Act explicitly covers adoption finalization. A parent adopting a child is entitled to up to 12 weeks of job-protected leave for placement and finalization purposes, provided the employer meets the FMLA coverage thresholds. Brightwell Family Services employed 63 people. The FMLA threshold was 50. They were covered. Carmen knew this. She had known it before she walked into Sandra's office. She had pulled the relevant Department of Labor guidance the evening before the meeting and read the specific regulatory language covering adoption-related leave. She had also, because she was a social worker who documented everything as a professional practice, written a contemporaneous memo to herself after the meeting. Sandra Holt's exact words. The date, the time, Carmen's questions, Sandra's responses. Then she had called her attorney. Now, if you believe the most powerful professional skill is knowing your rights before someone tries to take them, subscribe to Tangled Stories. I am Brett. Around here, the ones who read the regulation before the meeting always have the clearest path forward when the meeting goes wrong. Carmen's attorney was Elenas Park, employment law, 10 years of experience, the kind of attorney who became very precise very quickly when a client described a supervisor denying a federally protected leave request. Walk me through exactly what was said, Elenas said. Carmen read from her contemporaneous memo. Elenas was quiet for a moment. Did Sandra Holt put the denial in writing? She asked. Carmen had submitted her leave request through the HR system. Sandra had denied it through the same system. The denial was time-stamped and documented. The denial is in the HR system, Carmen said. Dated. Time-stamped. With Sandra's name on it. Elenas exhaled. Carmen, she said. What Sandra told you about FMLA not applying to adoption finalization is factually incorrect. The Department of Labor guidance is unambiguous. You are entitled to job-protected leave for adoption finalization. The denial of that leave is an FMLA violation. What are my options? Carmen asked. You can file a complaint with the Department of Labor Wage and Hour Division, Elenas said. That triggers a federal investigation. Or we can notify the employer directly first and give them the opportunity to correct the denial before escalating. Carmen thought about 8 years at Brightwell, about the 214 families, about Marcus. And she thought about Sandra Holt, who ran a family services organization and had told a licensed clinical social worker that her adoption finalization did not qualify for federal family leave protection. Notify the employer first, Carmen said. Give them the opportunity to correct it. But if they do not correct it within 48 hours, we file with the Department of Labor. Elenas sent a formal letter to Brightwell Executive Director Thomas Marsh on a Monday morning. It outlined the FMLA provision covering adoption finalization. It outlined the relevant regulatory language. It outlined Sandra's denial and the specific statement that FMLA did not apply. It outlined Carmen's entitlement to job-protected leave for the finalization hearing. And it requested written confirmation within 48 hours that the leave had been approved and that no adverse action would be taken against Carmen for requesting it. Thomas received the letter and called Sandra into his office. The conversation, as Carmen later heard from a colleague who had been in the adjacent office, was not brief. Thomas had spent 12 years in nonprofit management. He understood federal employment compliance requirements. He also understood that a family services organization that had denied FMLA protected leave to an employee adopting a child was not an organization that wanted a Department of Labor investigation on its record. He called outside HR counsel that afternoon. Outside counsel reviewed the letter, reviewed the FMLA provision, reviewed Sandra's denial documentation, and gave Thomas their assessment in one sentence. The denial was incorrect and must be reversed immediately. Thomas called Elena Park the same afternoon. The leave was approved within 4 hours of Elena's letter being received. Written confirmation was provided before end of business. Sandra Holt was not on the confirmation. Thomas had signed it himself. Carmen took her 3 days of leave. She attended the finalization hearing with Marcus on a Wednesday morning. The judge signed the order. Marcus became her son. Carmen had expected that the matter would end there. The leave had been approved. The hearing had happened. Marcus was home. But Elena had asked Carmen a question during their initial conversation that Carmen had not stopped thinking about. "Is Sandra Holt licensed?" Elena had asked. "She is," Carmen had said. "She holds a licensed clinical social worker credential. It is required for her role." Elena had nodded. "And part of the LCSW license requirements in Colorado include compliance with relevant federal employment law in professional practice contexts," she had said. A supervisor in a licensed social work context, who gives incorrect legal guidance about federal family leave rights in the context of a case involving a child welfare professional, could be subject to a professional licensing review. Carmen had thought about that for 3 days. On the morning after the adoption was finalized, she filed a professional conduct complaint with the Colorado Department of Regulatory Agencies, Division of Professions and Occupations, which oversaw LCSW licensure in the state. The complaint was specific and documented. Sandra Holt, a licensed clinical social worker serving in a supervisory role at a family services organization, had provided factually incorrect information to a licensed clinical social worker employee about federal FMLA protections in the context of an adoption finalization. She had used that incorrect information to deny a federally protected leave request. She had done this in a professional context in which accurate knowledge of family services law and federal protections was directly relevant to her licensed professional role. The complaint included Carmen's contemporaneous memo from the meeting, the HR system denial documentation, the Department of Labor regulatory guidance Sandra had contradicted, and Elenas' letter confirming the denial had been an FMLA violation. The Division of Professions and Occupations opened a formal review within 30 days. The review took 4 months. During those 4 months, Carmen continued working at Brightwell. Sandra Holt had been reassigned from direct supervisory responsibility over Carmen's team within 2 weeks of Elena's letter. Thomas had not announced it publicly. He had simply restructured the reporting lines with no explanation offered. The division review requested documentation from Brightwell, from Carmen, and from Sandra directly. Sandra retained a professional licensing attorney. The review concluded on a Thursday afternoon. The division found that Sandra Holt had provided materially incorrect information about federal FMLA protections in a professional supervisory context, that this information had been used to deny a legally protected leave request, and that the conduct was inconsistent with the professional competency standards required of a licensed clinical social worker in a supervisory role in a family services organization. The outcome was a formal censure. Mandatory continuing education in employment law and federal leave regulations, and a 2-year probationary period during which Sandra's license would be subject to enhanced monitoring. It was not a revocation, but it was a permanent mark on her professional record. In Colorado, licensing board outcomes are public record. The censure appeared on Sandra's license profile in the state database within 2 weeks of the decision. Sandra resigned from Brightwell 3 weeks after the outcome was published. Her LinkedIn described her departure as pursuing new opportunities in the social services sector. Thomas Marsh implemented a mandatory FMLA training requirement for all supervisory staff at Brightwell within 60 days of the division outcome. He also retained an outside HR compliance firm to conduct an annual review of Brightwell's leave management practices. He sent Carmen a personal written apology, separate from any legal context, acknowledging that the denial of her leave request had been wrong, and that the organization had failed to provide the support she deserved during one of the most significant moments of her professional and personal life. Carmen kept that letter in the same folder as Marcus' adoption finalization order. Both documents mattered. Both represented something that had been protected. One by a judge, one by knowing her rights before she walked into a supervisor's office. Carmen remained at Brightwell. Not because she had to, because the organization, under Thomas's leadership, had responded to the situation with accountability rather than defensiveness. Because the 214 families and the work that had produced them were real and worth continuing. And because Marcus was now her son, and the work she did every day was the same work that had once mattered to someone in his life before she did. She did not frame anything from the experience, she did not need to. She kept one note in her desk. Written the evening after the finalization hearing, after Marcus had fallen asleep and the house was quiet. It said 3 things. He is home. I knew my rights. I read the regulation first. And that, my friends, is how one case manager turned a wrongful FMLA denial into a federal compliance reversal, a professional licensing sanction, and the permanent adoption of her son, because she documented everything, called her attorney before she signed anything, and read the Department of Labor guidance the night before she walked into her supervisor's office. Because some supervisors give incorrect information about federal law and assume no one will check. And some employees already checked. The evening before the meeting even started, Carmen had already checked. Sandra found out on the morning the division published its decision. If this story moved you, subscribe to Tangled Stories, drop a like, and share this with every parent who has ever been told that their family does not qualify for the protections the law actually provides. Because here, every story has a twist. And sometimes that twist starts with reading the regulation the night before the meeting. I am Brett, and I will see you in the next one.